from Rouen University in Normandy, France, and I'm glad to register this video for you on the principle of non-discrimination in the framework of the European Convention on Human Rights, in order for you to have a conversation between yourselves and to work together with material. The European Court on Human Rights belongs to the Council of Europe, and if you don't know the difference between the Council of Europe and the European Union, please look at the document on this subject. The importance of the principle of non-discrimination is great, since the European Court of Human Rights considers that it is of a fundamental nature and that it underlies the European Convention on Human Rights in the same way as two other elements, the rule of law and the values of tolerance and social peace. And this in the case law called SAS versus France in 2014. You have a list of case law quoted in that video in another document. So first paragraph, we will deal with the idea of two standards for one principle. The European Convention prohibits discrimination by two different provisions, Article 14 of the European Convention and Article 1 of Protocol 12 of the European Convention on Human Rights. We need to start understanding why two provisions were needed and how they are articulated between themselves. Let's start with the Article 14 of the European Convention on Human Rights. Please pause the video and read the text in the attached document, pedagogical document called Pedagogical Document in number 1. And then you continue to listen to the video. So Article 14 of the Convention is incidental. What does that mean? The prohibition of discrimination concerns only the enjoyment of the rights recognized by the European Convention on Human Rights. The European Court pointed out that Article 14 has a horizontal effect. What does that mean? It means that the principle of non-discrimination may also be applied in situations of purely private nature, in other words, between two individuals, and not only between state and individuals as usual. For example, the court has sanctioned the interpretation by a national court of a clause of a will depriving the adoptive children of the benefit of the succession because it constitutes discrimination, in a case law named Pla and Ponsorno versus Andorra in 2004. You have it on the list. From now on, it is possible to incriminate the public expression of sexist opinion or images, particularly in the field of advertising. The question arises whether such criminalization is compatible with freedom of expression or not. The fact that the opinion or the images disseminated shocks a part of the population is indifferent. The principle of freedom of expression is not absolute, so state can interfere. One might think that a text incriminating behavior that harms the image of women would meet the condition for state interference provided for in Article 10 of the European Convention, since it pursues two elements, a legitimate goal, and is necessary in a democratic society. Why? Because it meets a pressing social need. Therefore, the principle of proportionality is respected, so such a text is not contrary to Article 10 of the European Convention. Images inciting violence against women or discrimination on gender constitute an attack on the dignity of the human person, which is still too often the case in advertising, thus contributing to the culture of machismo and the degradation of the image of women. The Frette case versus France in 2002, you have always the list of case law apart, concerns a refusal of approval of adoption considered as discrimination regarding their homosexuality by the applicants. If the applicability of Article 8 of the European Convention on Human Rights was contested by the French government, which considered that such a refusal is not a decision that interferes in the sphere of privacy, the argument has hardly convinced the court, which found that the fact of the case fell within the scope of Article 8 of the European Convention, even though the Convention, as such, does not guarantee the right to adopt a child. If homosexuality should not condition the refusal of accreditation, other criteria must be considered, such as adoption by heterosexual person, such as the environment, the emotional and the educational abilities of the applicants. Moreover, in the case of Gas and Dubois versus France, the court, after an in concreto study of the situation of the applicants forming a homosexual couple, concludes to a normal family life within the meaning of Article 8 of the European Convention. The court adds that sexual orientation falls within the personal sphere protected by the same article. Now it's time to deal in a B section about Article 1 of the Protocol 12. Again, please pause the video and look at the text and read it carefully in this teaching pedagogical document number 2. So this Article 1 of Protocol 12 completes Article 14, in that it prohibits discrimination more generally. In fact, the prohibition does not concern only the enjoyment of the rights recognized by the European Convention, as in the case of Article 14, but the enjoyment of any right provided for by law. According to the court's interpretation of that text, this article also goes beyond any statutory right. The court relies on paragraph 2 of that provision, which further provides that no person shall be discriminated against by a public authority. It appears from the explanatory report of Protocol 12 that the scope of the protection offered by these articles covers 4 categories of cases, in particular those where a person is discriminated against. First, in the enjoyment of any rights specifically granted by national law to the individual. Second, in the enjoyment of any right arising from clear obligation of public authorities under national law, that is, where such authorities are required by national law to conduct in a certain way. Third, from public authorities because of the exercise of a discretionary power, for example, granting certain subsidies. 4, because of other acts or omissions by public authorities, for example, the behavior of law enforcement official in dealing with a riot. Always the explanatory report also state that while the protocol is primarily intended to protect individuals from discrimination by state in a vertical relation, Article 1 requires parties to take measures to prevent discrimination, even in relations between the individuals, referred to as indirect horizontal effect, in opposition to vertical relation between state and individuals. This includes, for example, arbitrary denial of access to work, access to restaurants or services that may be available to the public by individuals, such as health service, water, or electricity distribution. However, the court has not yet had the opportunity to apply Article 1 of Protocol 12 to situation in question. In conclusion, a little more technical clarification, but very useful for all those who want to obtain recognition of having been a victim of discrimination, and also for lawyers. the prohibition of all discrimination protected by Article 14, and the right to an effective remedy, recognized this time by Article 13 of the European Convention, have no independent existence, since the provision setting out them can only be implemented in conjunction with another relevant article of the Convention. Discrimination exists only in relation to the exercise of a right guaranteed by the European Convention on Human Rights. Similarly, the right to recourse can only be understood because of a measure affecting one of the rights recognized in the Convention. However, this lack of independence did not prevent the Court from giving these two rights an autonomous scope, considering that they could be infringed without there being a violation of another guaranteed right. These 2 points were recalled in a case law case called Karl-Heinz-Schmidt versus Germany in 1994. You will find the following quotation in the attached pedagogical document number 3. So for the court to condemn a discriminatory practice, it must not only find that, first, a difference in treatment in the exercise of a right affirmed by the Convention, although, second, this distinction lacks objective and reasonable justification. I hope this video will help you to have a fruitful exchange of ideas.